Utah family courts rely heavily on custody evaluators and guardians ad litem, and that reliance is understandable given the emotional and factual complexity of custody cases. But the real problem is not that these professionals exist, it is that courts too often treat them as substitutes for adjudication rather than tools to assist it. Expertise is not evidence, and professional status does not transform opinion into fact. But you'd be hard-pressed to convince the courts of that in Utah. Custody evaluations are built on judgment calls shaped by assumptions, interview methods, and human perception, and the danger arises when conclusions are treated as independently verifiable findings rather than interpretations layered on disputed facts. Neutrality is not a credential, it is a discipline, and two evaluators can review the same family and the children in it and reach wildly different outcomes, which alone should caution against treating any report as dispositive. Utah law requires courts to make specific findings, and over-reliance on recommendations shortcuts that obligation, displacing judicial reasoning rather than supplementing it. That displacement harms parents, children, courts, and even the professionals themselves by shifting decisional authority without safeguards. Filtering a child's perspective through adult intermediaries does not eliminate influence, it conceals it, flattening tone, context, and creating ambivalence. This is not an attack on GALs or custody evaluators. It is a call for structural discipline, however. Evaluation should inform, not replace judicial findings. Opinions should be tested. Children's experiences handled with care rather than avoidance. And courts must remember that delegation is not decision-making. Custody decisions deserve rigor, not shortcuts, and when courts exercise judgment rather than borrowing it, legitimacy and fairness are preserved.